Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, a senator of Godfrey, the fifth kind of Van Jew, son of Folkville of Jerusalem. I'm here today with another marvelous lecture for all my subjects, all my heirs, all my ancestors who are descended from one kindred, one family. We know that's God's family, all right? The angelic beings who are called the Anglo-Saxon Berbers. I'm here with another marvelous lecture, and this lecture is going to pretty much be a reiteration of what has already been taught here from the Third Temple English Church of England. This particular lesson is going to pretty much involve or and take pretty much everything that we're subject to in regards to our status here in this territory now called America. And we know America is a misnomer. This is England. This is land that's owned by the Crown of England. All right. A lot of the information in regards to that has been taught on this platform. You can find it on other platforms as well, but it won't be as concrete as you'll have it here because everyone has an agenda. All right. It has always been an agenda with property that belongs to the church. We know that church property is entail property, and we know entail property is inheritable to those who are heirs, i.e., beneficiaries. So once and for all, I come to dot all I's, cross all T's in regards to this information of who this prophecy, this story, this ideology, however you choose to identify with it, I'm once and for all going to prove and show you that it was in reference to those who are descendants of the Third Temple English Church of England, being that we are the community of God's people known as the English people. All right. And this is very important to understand that not from your abstract stories, but from your concrete stories. All right. You need validated proof. All right. We can't live our life based off presumptions of what we presume things to be. It has to be evidence to support these conclusions. All right. So I'm going to bring you my evidence, my conclusions. All right. And it's all going to be based off just not just my family, but the surname of my family. All right. The origin where my family come from. All right. Shows you the power and authority that we have because my family name is my patronymic name. All right. It comes from my father. All right. My great grandfather. All right. My great grandfather. My grandfather was named Leotis Jefferson. My great grandfather was called William Jefferson. All right. They were from the Mississippi Territory. All right. The territory known as the Mound Territory, where the mound builders were associated with. All right. So once and for all, I'm going to show you if you're able to keep up or catch up and stay on this path, that it's very important to understand that you must have a relationship with the Third Temple English Church. Is a must. All right. You know, we represent the English Church of England, not the Church of England, the Roman Catholic Church of England. All right. Majority of your understanding about the land and who is controlling it is under the de facto teaching or the misnomer teachings of those who are teaching from the pews or the platforms of those who come under the auspices of the Church of England. and not the English Third Temple Church of England or the Third Temple Church of England, which is those heirs and successors who descended down from those who were protected by the Magna Carta for the protection of the English Church. Very, very, very important for you to understand that. So without further ado, let's get started. I do this in honor of my queen, Sister Godwinson from the House of Godwinson, Archbishop Belmont from the House of Belmont, my family, the Jefferson family, as well as all those noble families out there as well. And I do this on behalf of my grandmother, my great grandfather, my great great grandfather, and my great great grandmother. All right. This is for you. All right. It is January the 10th, 2024, which in the birth year will be 2974. All right. So everybody check your calendar. Without further ado, let's get started. I promise I'll try not to hold you all for too long, but I got a lot of information to get across to you, so I ain't gonna I'm not gonna promise you. I'm gonna try not to hold you long, but hopefully I can keep my promise to you. Keep that gift to you not to hold you long, but I ain't gonna promise you that. All right, let's get started. With all things, I want to give honor to my grandmother, my grandfather. All right. Leotis Jefferson and Ruth Jefferson. We know Ruth was supposed to be the grandmother of Jesus Christ. All right. And then my grandmother's have a name to be Ruth. All right. And I'm the reincarnation of who we know as Jesus Christ, which is none other than King Edgar the Peaceful, because he was called the King of Peace. This is synonymous with Jesus' term, the King of Peace. All right. So it's very important you understand that I'm giving you the concrete versus the abstract. This is my grandfather, Leotis Jefferson, and my grandmother, Ruth Jefferson. All right. This is in New Jersey, 386 Comstock Street, where we grew up as children. All right. Between Sanford Street and French Street. All right. So this is my grandfather, Leotis Jefferson, my grandmother, Ruth Jefferson. All right. I'm showing receipts. I'm showing my receipts. As you can see, Ancestry.com, Leotis Jefferson, this is my grandfather, born the 19th of January, 1913, Marion County, Mississippi. All right. His mother was Ida Rideout, and his father was William Jefferson, which will make Ida my great grandmother and William Jefferson my great grandfather. All right. William Jefferson was born in 1875. Ida Rideout was born in 1887 in Marion County, Mississippi. All right. My father was born in Tilton Walsh, Mississippi. All right. I can't even find Tilton Walsh, so I don't know where that name comes from. All right. Which gave birth to Nina Bruce Jefferson, which is my grandmother, Ida Mae Jefferson, which is her daughter. All right. As well as all her other siblings. All right. My grandfather was born in 1875, my great grandfather. In 1875 was a time when they had the freedmen were being freed from slavery, and they were allowed suffrage, a right to vote. But they passed laws in Mississippi to deprive them of the right of suffrage, i.e., a right to vote. All right. This was called the Mississippi Plan of 1875. Let's go there. All right. Everybody see that? Mississippi Plan. The Mississippi Plan of 1874 was developed by white Southern Democrats as part of the white insurgency during the Reconstruction era in the Southern United States. It was devised by the Democratic Party in that state to overthrow the Republican Party in Mississippi by means of organized threats of violence and suppression and purchase of the black votes. Democrats wanted to regain political control of the legislative and governing offices. Their success in doing so led to similar plans being adopted by the white Democrats in South Carolina and other majority black states. To end election violence and ensure that freemen were excluded from politics. The Democratic dominated state's legislature passed a new constitution in 1890, which effectively disenfranchised and disarmed most blacks by erecting barriers to voter registration and firearms ownership. Disfranchise was enforcement through terrorist violence and fraud, and most black people stopped trying to register to vote. This is why we don't do it today. All right? Exactly why we don't do it today. Because we don't get nowhere. Why? Because we don't have a system, a government in place to protect us. Because we know at the time of this government, we were enslaved. All right? Once we got free from slavery, we're still subject to the acts of what slavery indicated. All right? Those acts were still being done. This is what my grandfather was born into. All right? In Mississippi. My great-grandfather. All right? And my grandfather. All right. They migrated from Mississippi. My grandfather migrated from Mississippi all the way up here to New Jersey as a result of what was going on, going back to my great-grandfather, going back to the creation of the Mississippi Plan that was going on in Mississippi. Now, we know Mississippi was inhabited by Spain first. All right. Mississippi was under the authority of what we call Spain. All right. The first European discoverer of Mississippi was Hernando de Soto. All right, was Hernando de Soto. All right, we know that Mississippi was one of the original Confederate states, and you had the 13 colonies. We know that in England, slavery was prohibited. All right, so therefore, if slaves ran away trying to become emancipated, they were returned back to the slave masters in those Confederate states. All right, this came about what they called the slave fugitive laws. All right, where a slave could return back to his slave master as a result of the slave being what they call property, or i.e. chattel property. All right. Very important to understand this. All right. Because this going to go into what we talked about in my other lectures concerning the Dred Scott case. All right. The Dred Scott case. Very, very, very important. All right, let's get to it. So the Mississippi Plan was created by the Democratic White Party to deny people identified as black people or colored people, to deny them the right to participate in the right of suffrage, all right, the right to be able to vote, all right. This is through the Reconstruction era of the Southern states, all right, and the Mississippi Plan, and resulted in what we call an insurgency. Everybody see that? All right. So with that in mind, I want to go here. Isaiah 45 again. Isaiah 45:4. We know Cyrus was a Persian king who wrote or decreed a law to have the Israelites return back to their homeland, all right, as well as all their property returned to them, all right. This is a book from King James Bible, the King James Version. We know King James was a Scottish king, all right, who descended down from the kings of Alba, all right, kings of McAlpine, all right. I've talked about that in my previous classes, all right. So we see that in chapter 45, King James Version, and we know King James was a Scottish king. He wasn't an English king, all right? He wasn't an English king, all right? He was a king that came about with the creation of what they call Great Britain, all right? Great Britain came about in 1707, and it came about through the Union of the Crowns in 1603, all right? Those histories that you must understand to get a full narrative of where I'm trying to go with this, all right? So chapter 45, verse 4. For Jacob my servant's sake, and Israel mine elect, I have even called thee by thy name. I have surnamed thee, though thou have not knoweth me. So the Lord is speaking about his descendants, his heirs, from the biblical perspective, as told in the Bible written by King James. And we know Jacob's name was changed to Israel, all right, because he wrestled with the angel, all right. So it says, for Jacob my servant's sake, and Israel mine elect. And we know Israel denotes to the 12 tribes of Israel. And he said, he hath called thee by thy name, and have surnamed thee through, and has not known thee, but thou hast not known me. So he has given you a surname. A surname is different from a given name. All right. A surname is a name given to you to know your descendancy. A given name is just a name somebody to know you by. You know, just like your first name. All right. But thou hast not known him according to thy surname. All right. Because your understanding of each verse, when you read this verse, is from an abstract. Because how could God give you a surname when God and the creation story is not a physical man? All right. Spooks don't have surnames. They don't have surnames. So whoever is speaking here at this time on behalf of Jacob, his servant, and Israel, his elect, he said he called them by their name. To call is a form of speaking, calling forth, all right, by name, by way of their surname. So he was calling them individually, collectively, by their surname, because we all have surnames denoting to our family, our descent. All right. Verse 5, I am the Lord, and there is none else. There is no God beside me. I girded thee that thou hast not known me. All right. So somehow we have lost sight of who is the Father who we descended down from. All right. Because he's our Father. He gave us our surnames. All right. We know we got a lot of people in our family that had different surnames, but we are all family. All right. Which have their own family with the same surname, contrast to their given name. All right. So it's very important to understand where I'm going with this, because we're talking about the surname given to you by your creator. All right. We know the creator is not physical. We know when you're dealing with creation and our creation, at our being created as creation, you have to go into your DNA. All right. Your molecular structure, biological memory. All right. Your cells. All right. There's nothing spooky about it. All right. Cells dealing with the sense to be able to procreate. All right. Your ancestors, you have to remember that. All right. Let's move forward. We know Mississippi was first discovered by, as I said, Hernando de Soto. All right. Hernando de Soto. Why is this important? All right. Why is this important? Because we know that the Confederate States practiced slavery. All right. And this goes all the way back to the territories that goes back to the time of the Kingdom of Spain and the Kingdom of France. All right. We know those territories that was under the Kingdom of Spain and the Kingdom of France here on this landmass, here in this territory that we call America, all right, was subject to a king from Spain or France. And we know that the territories that these kings had was succeeded to what we call Great Britain, right? And we know when the land was ruled by a king, the land became allodial. All right. When the land was ruled by a king, the land became allodial. All right? And we're not talking about the spook. We're talking about a physical king, a king that had a surname. Very important to understand that. And we're talking about allodial land. All right? Let's move forward. We know Hernando de Soto. Let's visit him. Hernando de Soto was a Spanish conquistador who was involved in expeditions in Nicaragua and the Yucatan Peninsula. He played an important role in the Francisco Pizarro conquest of the Inca Empire in Peru, but is best known for leading the first European expedition deep into the territory of modern-day United States, through Florida, Georgia, Alabama, Mississippi, and most likely Arkansas. He is the first European document as having crossed the Mississippi River. Yes, the indigenous lands of my forefathers, your forefathers, here on this landmass, all right, being migrated, colonized, conquered by a European by the name of Hernando de Soto under the authority of a Spanish king. All right, a Spanish king. Hernando de Soto was from the House of Castilian. He was a Castilian. That was his nationality. All right, he was Castilian. Everybody see that. So when you're looking at Castilian, you must take it back to the kingdom of Castilian, and the founder of the kingdom of Castilia was Ferdinand III of Castile, which brings us here. We're talking about different crowns. We're talking about the Frankish crown, the Spanish crown, the English crown, the Scottish crowns. The key word is the crown. That's the key word. All right. The office of the crown. Whoever sits in the office of the crown controls crown land. All right. Whether you're de jure or de facto, you control the crown land. All right. If you're de facto, that's by way of what we call prescription of sovereignty. Somebody claiming to be the sovereign on land that they do not own. All right. Which is a form of what we call prescription of easement, which is a non-possessory use of property that don't belong to you. All right. We've been through this already. We're going to go through it again. Ferdinand III, all right, called the saint, was king of Castile from 1217 and king of Leon from 1230, as well as king of Galicia from 1231. Very, 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 very important for you to understand that. All right. So Hernando de Soto was a conquistador who did an expedition on behalf of the king of Castile, Ferdinand III, or whoever it was. I know he was the king of Castile. Why I picked Ferdinand III? Because Ferdinand III is the father of Eleanor of Castile. All right. Ferdinand III, king of Castile, is the father of Eleanor of Castile. Why is this important? Because if Ferdinand III is ruling territory here known as the Spanish territory that came under the jurisdiction of the Frankish territory by way of the Treaty of Paris of 1763. Everything that Spain had, they succeeded to France. Everything that France had, they succeeded to Great Britain. And Great Britain is a result of the unification of Great Britain with England, with Ireland and Scotland in 1707. Prior to that, there were separate crowns. All right. Okay. Why is this important? Ferdinand III was the king of Castile. Now, what is the king of Castile? And what does Castile Empire and the minors of Castile consist of. We're going to visit that real quick. This all takes place on the Iberian Peninsula. All right, ruling territory over here in Western North, what they call North America. All this is crown land. All right, the monarchs that assisted the kingdom of Castile. All right, by way of what we call the Iberian Peninsula, you get into what we call the Atlantic slave trade. All right, or the triangular slave trade, or the British slave trade, or what we call slavery in Britain. We're going to talk about all that today. All right, slavery in Britain, and when you're dealing with slavery in Britain, you have to automatically go into what we call the Dred Scott case. All right, you have to go into what we call the Dred Scott case, which we will do. All right, so we see that Al-Andalus is the southern part of the Iberian Peninsula, which was under Islamic rule for 700 years. In medieval history, Al-Andalus was a name given to part of the Iberian Peninsula and Septimania, governed by Arabs and North African Muslims at various times in the period between 711 and 1492. Okay, who else? The Almohad. The Almohad Khalifa or the Almohad Empire was North African Berber Muslims empire founded in the 12th century. We know you got the Berbers and you got nomadic Berbers, all right? You got dark-skinned Berbers and you got the light-skinned Berbers. The light-skinned Berbers are the nomadic Berbers that they call Amazigh. All right, they're called the Amazighs, all right? But as you can see, those who took place under the what we call the kingdom of Castile were composed of the Al-Andalus, the Almohad, the Almovid. All these are Muslim dynasties. Aragon, Asturias, Castile, Catalonia, Cordoba, Emirate, Galicia, Granada, Leon, on into the present day style terms that they call themselves now. All right? So as we can see, they are all considered part of the kingdom of Castile. Everybody see that? All right. Now, why is this important? Why is this important? Because I descend down from the Plantagenet dynasty. You know, the Plantagenet dynasty gave birth to the Angevin, and the Angevin gave birth to the Yorks and the Lancaster branch. All right. We know Edward I was the son of Henry III. All right. We know Edward III gave birth to the house, gave birth or was part of what we call the House of Yorks. And Henry IV was part of the Lancaster branch, which were cadet branches of the Plantagenet house, all right, which was founded by Godfrey, all right? Godfrey, the fifth Calaban Jew, son of folk who loved Jerusalem, all right? So Ferdinand III was the father of Eleanor of Castile. Let's put her up real quick. Eleanor Castile was the Queen of England as the first wife of Edward I. She was well educated as the Castilian court, all right? She also ruled as Countess of Pontitu Sojuis from 1279, all right? We're not going to get on to her life because she was a Roman Catholic and she was Frankish, all right? Spanish, all right? Her spouse was who? Edward I, King of England. Everybody see that? He was called the Hammer of the Scots. Once again, he was called the Hammers of the Scots. All right? And we're going to associate the one who were warm with the Scots and who gave Scots their independence, and he has authority over here in North America. He's mentioned in statutes, he's mentioned in case law. All right, yes, this Edward I, son of Henry III, Yes, he's mentioned in case law. He's mentioned in New Jersey revised statute. This king, he is the one who protects our estate, our entail estate. He passed legislation to protect our entail estate. Why? Because he was the king. He personified the crown. So therefore, all crown land was under his control and is inseparable. Let's prove it. All right. So Eleanor Castile, spouse was who? Edward I, who was her father? Ferdinand III of Castile. Everybody see that? He was a Roman Catholic. All right, let's move forward. Edward I. Who was Edward I? We know his wife, Eleanor, was a descendant of the Spanish crown under Spanish King of Castile, which has territory over here in North America because all the conquistadors were done on behalf of that king, Ferdinand III, all right, who was the father of Eleanor Castile, who was married to the King of England, all right? He was married to the King of England. Let's read a little bit about him before we move forward. Edward I, also known as Edward Longshank in the Hammer of the Scots, was King of England from 1272 to 1307. Concurrently, he was Lord of Ireland, and from 1254 and 1306, he ruled Gascony as the Duke of Aquitaine. All right? In his capacity as a vassal of the French kings. Before his ascension to the throne, he was commonly referred to as Lord Edward, the eldest son of who? Henry III. All right? Everybody see that. All right? Henry III. Now, these are the big players in this game. Big players in the game. All right? These are big players in the game. Everybody hold that thought. We're going to go deeper. Okay. Okay. So we have Eleanor of Castile, and we have Edward I, all right? And we're associating Eleanor Castile and Edward I with territory over here in what we call North America, all right? Because we know all land belongs to the crown. That's a fact. All land belongs to the crown, all right? We first must understand that, all right? Where I want to go. New Jersey Revised Statute 46:3-6. These are legislative statutes in regard to conveyance and transfer of estates. All right, and there's only two types of or three types of estates: entail, fee, and simple. Parts of two. Entail, no, it's actually three: allodial, entail, and fee and simple. All right, allodial, entail, fee and simple. Land that's allodial automatically belongs to the crown. If it's entail, then that means that it's for an heir. If it's fee and simple, then it's for anybody other than the heir, which is a violation of law. All right. I'm going to show you in the statute. I'm going to show you in legislation. I'm going to show you in case law. All right. Pertaining to over here, because this is a New Jersey advice. This is a New Jersey legislative statute that clearly states in the year 2022, and I read, all gift grants or conveyances made prior to after July 4th, 1776, of any estates in regards of an inheritance that was given by way of some letter patent, a deed. All right, if you got a deed is an instrument of conveyance of a transfer of property, not the land. All right, not the land. Because if it's the land, then it must be under the seal guaranteed by the king's seal. All right, under the great seal of the state or any other manner by the state, by the legislature thereof, or by the commissioners or agents or forfeiters of the states, or by other lawful and competent authority under the state, shall be and remain allodial and not feudal, and shall forever be and continue in free and pure allodium only, forever discharged of all feudal tenures and the instances thereof, and all other services whatsoever. So all land that was declared by way of prescription of easement under somebody claiming to be a sovereign had to turn back to the allodial land of the crown. Because the United States, the highest form of ownership of it's what we call fee simple. And fee simple is a result of what we call common recovery. All right, and a legal process. All right, so we see a land here is allodial. All right, so if it's allodial, that means there is no feudal tenures being given out. All right, there's no feudal tenures, estates to lands, no bundle of rights given out to anybody. I don't care what type of instrument you hold, showing the conveyance. It's all a prescription, which is subject to what we call reversion or remandment. All right, reversion or remandment, because their encumbrance is placed upon or a lien placed upon it, which denotes to what we call a cloudy title. A cloud in the title. All right, let's look at the legislative. It's a statute. New Jersey Revised Statute 2022. From and after June 12, 1795, no fine or common recovery that has been or shall be entered, made, had, or suffered in any court of record of this state shall operate or be construed to be a conveyance or assurance of any of real estate, or in any way bar a issue of entail. Remember, there's only three: allodial, entail, and fee simple. All right? Allodial, entail, and fee simple. I already showed you that the land is allodial. All right? And if it's allodial, it's left for those who are heirs to the land that's allodial, and that can only be entail. And this is saying that there can be no bar on issue of entail or the reversion or remandering of the lawful claims and entries in any uses of custom to the contrary is anywise notwithstanding. All right? Is notwithstanding. So if you hold it deep, fee, and simple, presently, it's notwithstanding in any court of law. In lieu of what we call some inheritable interest, i.e., equitable interest in an estate. Very important to understand that, because common recovery, as you see in the statute, it's an unlawful practice. Why? Let's see. This is what you should be taught. Common recovery was a legal proceeding in England that enabled lawyers to convert, change, manipulate, disguise, abolish an entail estate, a form of land ownership also called fee-tail, into absolute ownership. Fee simple, that's what it's called. All right. This was accomplished through the use of series of collusive legal procedures, some part of which fictional and other unenforceable, and therefore it was null and void. It was devised and perfected by lawyers in the second half of the 5th century. A 1472 case known as the Thornton case increased its popularity. All right. This came after the dawn of its conditional bust. This was the law passed by who? Everybody say it. Edward the First. All right, Edward the First. It was called the Law of Entail Estates. Let's read it. Entails were originally designed to keep ownership of land within a family. Thanks to the effect of the statute de donis conditionalibus, the intent of an entail could not be broken. This meant that the land in fee-tail could not simply be sold, transferred, or mortgaged as whatever the current owner did with it. Ownership would automatically pass on the deaths to those specified by entail. Did y'all hear what I just said? By entail. While entail performed a valuable function in the 13th century when the donis condition was enacted, by the 15th century the court had extended their scope so that they were now perpetual. You hear this, y'all? Perpetual. Entail estates known as the donis conditionalibus were perpetual. So what is the donis conditionalibus? Just look at that. Because this stopped common recovery practice, i.e. fee simple. So whatever y'all doing in regards to home ownership, not land ownership, but home ownership, is by way of a mortgage, is a violation of law. Right? I'm going to prove it to you. The donis conditionalibus, or the Estates Tell Act of 1285, is a chapter of the English Statute of Westminster. It originates the law of entail forbidding landowners to sell his land except to his heirs. Did you hear that? So if you're not an heir, you cannot own land here in North America. Well, now, King, they ain't talking about North America, talking about England. No, they're talking about right here. How we know? Let's see. Somebody's going to jail. Somebody's going to jail. Here's the proof. They stole your estate. Here's the proof. (2022) statute. Estates entail abolished. So estates entails were abolished. That means that there is no heirs. Did y'all hear what I just said? If estates entails were abolished, then that means that there are no heirs. It is streets. It becomes abandoned property. Why? Because they don't own land estate in entail here in North America. They own it in fee and simple, which is a result of common recovery, which they said was unlawful. They know it's unlawful, but when the heirs come back, nobody else can bring a claim in regards to an entail estate. Only an heir can, and they don't think no heirs are here. because the highest form in the United States is fee and simple. So if you get a grant or you incorporate an instrument or a deed into the city clerk office, then it's automatically denotes to a fee simple estate, right? Which is prescription to use something that you do not own. It's not yours. They know it. Why? Because they have well what they call quin impetuoris. All right, which means you cannot sell it, called subjugation, but you can hold it fee simple. All right, as custodians. So all of you is nothing more than custodians on property that you don't own. Let's prove it. Because the state of New Jersey abolished the entail estates that were reserved for heirs. It said it right here. Whenever any conveyance, will, or instrument in writing shall hereafter this statute was enacted, be made, whereby any grantee, devisee, or a person shall be seized in law or in equity of such estate in any real estate, as under the statute of the 13th of Edward I, an English king and New Jersey statute called the Statute of Entail, which we just read, will have been held in the state in fetail of any type of character. Now, such conveyance, will, or instrument shall vest in the state and fee simple, and such grantee, devisee, or other person. So they told you they stole it under common recovery, because common recovery is changing entail into fee simple. They admitted it. Now, do you want to be a part of the solution, or do you want to remain a part of the problem? Because right now, you're a part of the problem. All right? Let's prove it. Here's some more proof. By via the statute. They think we dead. Alienation of freehold. We just read that the statutes and entail said you can't sell land. All right? That belongs to an entail heir. All right? From after March 8th, let me make sure y'all all see this. So I ain't just talking. I'm reading legislation to you. Statute quin impetuoris terrarum. From after March 18th, 1795, any freeholder may give, sell, or alien the real estate whereof he is, or at any time shall be seized in fee simple or any part thereof at his pleasure, and such donee, purchaser, or alienee shall hold the same free and tenure of service to the donor, seller, or aliener. All right, so that means that you're able to alienate land when the quin impetuoris said you could not do it. The state of New Jersey did something that the King of England said you could not do. Let's find out. Why has nobody else find this out? No one. Why has no one brought this to revelation to the citizens, to the subjects? Quin impetuoris is a statute passed by the Parliament of England in 1290. The Jews were expelled in 1290. The Scottish kings got their independence in 1295. All right, they were warring with this king Edward I. All right, these were the kings who wrote your Bible. All right, these were the kings who were sitting on the crown of England, ruling the lands here in England that were given to the 13 colonies. The kings of Scotland. Yes, they did all this. All right. Quin impetuoris is a statute passed by the Parliament of England, not Scotland, not Ireland, but England in 1290 during the reign of Edward I that existed from there all the way to the present up to the 1795 when they changed it from what the status of the legislature said to what they wanted it to mean, saying that now they can alienate the land when the original quin impetuoris said you could not alienate the land. Let's read it for ourselves. Quin impetuoris is a statute passed by the Parliament of England in 1290 during the reign of my ancestor Edward I that prevented tenants from alienating their lands to others by subinfeudation, instead requiring all tenants who wish to alienate their land to do so by substitution. Substitution is by way of fee simple. All right? By fee simple, meaning that you can hold it under the fee simple guise of either fee simple, fee indefeasible, or life terms. All right? But they're subject to encumbrances as a result of reversion or remanagement when somebody puts a cloud on the title. All right? As a result of not having a clear chain of title. All right? This is why core warranties are issued out. It says the statute alone, which is companion status core warranto, which is prerogative writ, also passed in 1290, was intended to remedy land ownership disputes and consequent financial difficulties that have resulted from the decline of traditional feudal system. Everybody see that? Right here. By effectively ending the practice of subinfeudation, Queen Victoria's hastened the end of feudalism in England. Although it had already been on the decline for quite some time, direct feudal obligations were increasingly being replaced by cash rents and outright sales of lands, which gave rise to practice delivery and maintenances or bastard feudalism. The retention and control by the nobility of land, money, soldiers, and servants via direct salaries and land sales and rent payments. By the mid 15th century, the major nobilities were able to assemble estates, sums of money, and private armies on retainers through post Queen of Victoria's land management practices and direct sales of land. It is thought by historians such as Charles Plummer that this then developed into one of the possible underlying causes of the War of the Roses. Did everybody hear that? The underlying cause for the War of the Roses. All right? So alienating land, which is called subinfeudation, is a violation of law because you cannot sell land that's entail. Because entail land is called crown land. All right? Entail land is called crown land. Let's just prove it. Crown land, sometimes spelled crown land, also known as royal domain, is a territory area belonging to the monarch, who personifies the crown or the English throne. The crown and the English throne are synonymous. All right? Whether you're talking about the English throne, Scottish throne, Irish throne, Spanish throne, Frankish throne, you're talking about those particular crowns. You're not talking about the English crown. The English crown we're talking about now. All right? It says crown land is a result of the personification of the monarch who represents the crown, which is also equivalent to an entail estate and passes with the monarch being inseparable from it. Y'all all focus on that real quick. All right? Focus on that real quick. Being inseparable from it. The king or the monarch personifies the crown, which the property, i.e., crown land, is a part of the crown, which is inseparable from the monarch. So that's why it says the land is allodial. All right? That's why the land is allodial. All right, so everybody read that, crown land. Most of y'all don't understand that concept yet, but you will today. I don't know why people. Who personifies the crown. All right, where I want to go now. So you said crown land is what? Entail, right? All right, crown land is entail. We know what entail is. Let's read what entail is. All right. In English common law, fee teller entail or telesy in Scottish law is a form of trust, a fiefment, established by a deed or a settlement that restricts the sale of inheritance. All right. So that means if it restricts the sale of inheritance, then that means that it's not allowed to be subjugated. All right. So what are they doing? They're selling it. You can't never own it because you can never own the land. You can never own the property because you can never own the land. All right. The land is just vacant because the owner of the land is not here. Right? That's why fee simple is the highest form of it because it's assumed to be bona vacationia, abandoned property. It's abandoned because they assume that the heirs abandoned it. It's either you abandon it or you're dead. One of the two. If you abandon it, it becomes bona vacationia, which is chiefs to the crown. All right. We know the crown represents crown land. If it's interstate, that means there are no heirs. All right. There are no kindred. All right. So it can't be entail. So English common law, fee teller entail. I ain't gonna say telazar because that's how they stole it. It's a form of trust established by a deed of settlement that restricts the sale of inheritance of an estate and real property and prevents the property from being sold, devised by will, or otherwise alienated by the tenant in possession. The tenant in possession is by way of prescription of sovereignty. All right? Prescription of sovereignty. All right? And under prescription of sovereignty, they invoke what we call the eminent domain power. But under the eminent domain power or police power, they must protect the public trust, which is called public land or federal land of the public domain. All right? Federal lands are public lands, which is called the public domain. Everybody got to understand that. All right, let's get on. It says, uh, in English common law, fee teller entail is a form of trust established by a deed of settlement that restricts the sale of inheritance of the state and real property and prevents the property from being sold, divided by will, or otherwise alienated by the tenant in possession, and instead causes it to pass automatically by operation of law to an heir determined by the settlement deed. This is called statute of disposition. All right? Statute of disposition. Fee tail deeds are in contrast to fee simple deeds, possessors of which have a unrestricted title to property and are empowered to bequeath or dispose of it as they wish, although it may be subject to a lodio of the monarch or of a governing body with the power of eminent domain. So if it's eminent domain, that means that the monarch is missing. Because if it's a lodio, then the monarch is there. We got a statute saying that the land is a lodio, but the monarch is missing. How can that be? As a result of what we call the entails being abolished. That was set up by Edward I here in New Jersey, and we know New Jersey was under the crown, under the New Jersey Provincial Council. All right? Show you that the land is allodial again. We can move on with the lesson. All gifts, all grants are allodial. All right? All gifts, grants, conveyances, however you got it, is on allodial land. If it's on allodial land, then it belongs to the crown. And we know crown land is personified by the monarch who sits on the crown, which you call the English throne. All right? There you have it in statutory form. All right? You have it in statutory form. Forty-six 3-12. Warranties by life tenants void as to reversions or abandonment. A warranty made by a tenant for life or real estate should be inoperative and void against all persons to whom such real estate shall descend or come into reversion or remandament. That only comes about when you're acquiring the title, trying to move a county title, because warranties are what we call insurance. All right, that denotes to how you own it or what type of rights you have in regards to the ownership, which is usually what they term uh, quiet possession, or quiet use. Quiet possession or quiet use. All right, that's what they term it. All right, but you don't have quiet use and quiet possession because the land is what? Allodial. All right. Right here. You see, New Jersey Revised statute says that the land is allodial, and we know it's allodial because it belongs to the crown. Here in New Jersey Provincial Council in 1776. They told you in the statute 1776 that the land is allodial. Why? Because it's the crown. Everybody see that. I don't know. You can turn your head, you can do whatever you want, but it's right there in front of your face. The crown, 1776. Let's go back to the statute. So there can be no miscomprehension about what's being said to you today. $1,776. You hear that? 1,776. All grants, gifts, or conveyances made prior to and after July 4th, 1,776 of any estate of inheritance. Got to be an entail. The only thing opposite of that is fee simple. By a letter patent under the Great Seal of the United States, Great Seal of this state, or any other manner by the state, by the legislature thereof, or by the commissioners or agents of forfeited estates, or by other lawful competent authority under the state, shall remain allodial and not feudal, and shall forever be and continue free periodium, only forever discharged of all feudal tenures and the interest thereof, and all other services whatsoever. All right, let's get more confirmation on this. Crown owns the land via allodial title. You have an interest via deed. All right.
It's not freehold. The land is owned by the crown. All the land is owned.
I'm a farmer in Minnesota, and you're saying that my land is owned by the Queen.
Yes.
I'm a farmer in Mozambique.
Your land is owned by the
Queen of England.
The Queen of England. She owns all the land. So what happens is you own that piece of brick that's sitting on it that they call freehold or your house. You own that. You don't own the land. So the land, the allodium title, is to own your land. So you can put a sign up that says no trespassing, private property. When you put that sign up, you have to own the land. Just owning the house doesn't mean anything. It's the land they want. See? The bank takes the house, which is part of the crown, and the crown owns the land.
Okay. The crown on the land. All right. Not the king. The crown on the land. All right. But when they own it under the Roman Catholic Church, i.e., the Church of England, contrast to the English Church, by way of the conversion of the Anglo-Saxon to Christianity, and by way of the Christianity, we accepted the servitude that comes along with Christianity. All right, which we go into when we get into the Dred Scott case. Let's continue.
Acting as your strong man. Now, when we reclaim ourselves from this fiction,
I'm gonna play it twice.
As people, many of us do it.
Yeah.
What then do you see? How?
Because she's wrong.
The dissolution of government, dissolution of this behemoth, this Molochite monster that has taken over our lives, indentured us into bondage slavery all around the world. 7 billion souls owned and controlled, indentured to a couple of hundred national reserve banks themselves, indentured into the Bank of International Settlements, that control through the US Treasury, the Federal Reserve, the IFC, the IMF, the World Bank, and so on, back to the Crown of England, and behind that, the Vatican. So all of that grotesquerie, that fiction, when do you see us as a people of the world reclaiming real reality from that fiction? And how is that likely to play out?
I think if people get to know and they come together, it doesn't take hundreds of millions. 1 million sovereigns get together can make a hell of a lot of difference, because the word spreads from one to the other once people get to know the law, what they're under, and what they're doing with them, and how they're making. You see, they make things to distract you, like the news and all this fake, all this stuff, television, and this is what they do. So once people can get together, if 100 people go to the bank and all keep taking out £100, before the end of the day, the bank will close. It's very simple if people get to understand what's going on. And it will be good for them to know, because we need to stop this. We need to stop what they're doing to people, hurting people for no reason. They can put people in poverty.
And by they, we're talking about the parent corporation here. The banks and governments and justice systems all working to penalize and harvest humanity.
Yeah, they're in bed together, everybody. They said, if they send you to the Citizens Advice Bureau, don't even bother to go, because they're working too with them. Everybody they have in their pocket. And it's very sad, because people will do things to other people for very little money.
Are you hopeful with humanity?
I am, very much so.
Okay. I'm going to play it again. I'm going to play this again. It's very important to understand, because she's misguided. All right. About the crown. All right. She's misguided about the crown. She keeps talking about when everybody wake up. Everybody is not going to wake up until they're called by the one who restores order. And that can only be personified by the crown, the person who personifies the crown. Those who were personified the crown and what they were talking about were the ones who enslaved you. All right? Don't throw the baby out with the bathwater. All right? We see that the land was the Lordio in the statute, but the land is no longer entail as a result of abolishing the land that was entail as stated by Edward I in the statute. And we know Edward I, or the Plantagenet crown, in the statute was ruling over here in the territory called New Jersey, which was under the authority of the crown. So it wasn't until after Edward I put these laws in place that they try to usurp it again, which is the reason why you got the colonists coming over here to the Settlement Act of 1702. That's why you have Great Britain in 1707, which brought slavery over here to North America, and then it was incorporated in the colonies. All right? It was incorporated in the colonies by the first legislation, first article of the Constitution. Slavery was brought over here. And it was protected by the fourth article of the Constitution once they got the players in their position through Article 2 and Article 3. I'm going to prove it today. All right? So I'm going to play this again. The crown is personified by the person who personifies the crown, which then entails own crown land, because the land can never separate from the church. It's just a question of which church are you talking about. They're talking about the Roman Catholic Church, all right, under the Vatican. We're not talking about that, because if you know the history, we were converted by the Vatican in 597, going back to the origin of the Roman Catholic Church, going back to Constantine. We were converted in 597. All right. And that's why in the 9th century, our Jesus Christ, King Edgar the Peaceful, reformed the English Benedictine Reformed Monastery and removed the secular clergy, all right, to restore the order that the English church, when it was associated with the English crown, i.e. the English throne. All right. I already talked about that. For the sake of time, I'm not going to talk about it now. Just replay this again. Now, I'm not going to intervene. I'm just going to let it play out.
What is a loading title? Why is it so important?
Okay, a loading title is important because you do not own the land. They tell you it's freehold, but it's not freehold. The land is owned by the crown. All the land is owned by the crown.
I'm a farmer in Minnesota, and you're saying that my land is owned by the Queen.
Yes.
I'm a farmer in Mozambique.
The land is owned by the Queen.
The Queen of England.
The Queen of England. She owns all the land. So what happens is you own that piece of brick that's sitting on it that they call freehold or your house. You own that. You don't own the land. So the land, a allodium title, is to own your land. So you can put a sign up that says no trespassing, private property. When you put that sign up, you have to own the land. Because owning the house doesn't mean anything. It's the land they want. The bank takes the house, which is part of the crown, and the crown owns the land. That's how it works. And you don't own anything. Ever. You are just a mere user.
So long as you are acting as your strong. Now, when we reclaim ourselves from this fiction, and we do it as a people, many of us do it.
Yeah.
What then do you...
He said, when we reclaim ourselves as a people, and many of them do it, this is what they're doing now in regards to the assumption of that they got a trust. They don't have no trust. You never had a trust set up for you. The trust was set up for the church. The trust was set up for the church under the statutes of Mortimer, which was passed by who? Edward I. All right, so she doesn't understand the intent of why this trust was set up in the first place and for who it was set up. Let's hear it.
How do you see the dissolution of government, dissolution of this behemoth, this monarchic monster that has taken over our lives, indentured us into bondage slavery all around the world, 7 billion souls, owned, control, indentured to a couple of hundred national reserve banks themselves, indentured into the Bank of International Settlements, that control through the US Treasury, the Federal Reserve, the IFC, the IMF, the World Bank, and so on. That's the Crown of England, and behind that, the Vatican. So all of that...
Did you hear that? Behind that, the Vatican. All right? So the Vatican has usurped the Crown of England by putting people in positions sitting on the crown of England, which they are not de jure, they're de facto, which denotes what we call prescription of sovereignty. Somebody claimed to be the sovereign and they're not, which is how they own the land through what we call prescriptions of easement. And that's not allodial. Let's look at prescription of sovereignty. Prescription of sovereignty is an international law and sovereignty transfer of a territory by open encroachment by the new sovereign upon the territory for a prolonged period of time, acting as the sovereign. We see who the true sovereign is in the statute. Edward I. Who are the acting sovereigns? King James and all those de facto ones who brought slavery into England by way of what we call the unification of what we call Great Britain as established by the Dred Scott case. All right? An open encroachment by territory by a long period of time, acting as the sovereign without protest or contest by the original sovereign. They separated king and parliament under the Articles of Confederation. It is analogous to the common law doctrine of easement by prescription for private real estate. So it's no longer public. Now it's private. It's no longer the public domain. Now it can be sold at foreclosures and subject to the easements and the coverages under the police power through the eminent domain power that the state have, being that the property has now become bona vacationia, abandoned. All right? Abandoned. This is common sense. All right? Let's move forward.
When do you see us as a people of the world reclaiming real reality? And how is that like?
I think people get to know and they come together. It doesn't take hundreds of millions. 1 million sovereigns get together can make a hell of a lot of difference because the word spreads from one to the other. Once people get to know the law, what they're up to, what they're doing, and how they're making. You see, they make things to distract you, like the news and all this fake, all this stuff, television, and then this is what they do. So once people can get together, if 100 people go to the bank and all keep taking out the £100, before the end of the day, the bank will close. It's very simple if people get to understand what's going on. And just stop this. We need to stop what they're doing, hurting for no reason. They can put people in poverty.
And by they, we're talking about the parent corporation here. The banks.
You hear that? She said the parent corporation. The parent corporation. We know there's two types of corporation. Corporation sole and corporation aggregate. All right? The Crown is not a corporation aggregate. All right? She's talking about all the sovereigns. There can only be one sovereign. There can only be one sovereign. There's only one God. All right, if you got a bunch of people in creating something, then it'll never get created because he might want it done his way, he might have wanted his way, they might want it their way. So it's a bunch of confusion. All right. Power is dangerous in the hands of fools. All right, so we're talking about crown lands. All right, we're talking about crown land. All right, and she said that it's governed by a parent corporation. So she don't really know what the crown is if she said a parent corporation. Because if a parent corporation is aggregate, then there's a bunch of people who make up the corporation outside of their natural selves. All right? Outside their natural self. When you go to McDonald's, you're employed at McDonald's for 8 hours or any other job that you go to. That's the same way for citizenship here in North America. All right, but in North America, it's 24 hours a day, 7 days a week, 360 days a year, or how many years there is in the years to come and the years that were before it. This is your destiny. It's already edged in stone. It's already set. You must understand. So what is the crown land? Before I move on with my lesson, crown land, also known as the royal domain, is a territory area belonging to the monarch, who personifies the crown. Not a bunch of people, not a parent corporation, not banks, not financial institutions, etc. It said the monarch who personifies, who incorporates, who incarnate to fit the description of that individual who represents the crown land on behalf of those who are to inherit crown land through what they call entail estates. All right, very important. What is the crown? Before I move on, the concept of the crown is the concept of the crown as a corporation soul. You hear that? As a corporation soul developed first in the Kingdom of England as a separation of the physical crown and property of the kingdom from the person and personal property of the. So the property don't belong to the monarch; it belongs to the crown, and the crown is represented by the church. We know that church and state separated under the Virginia Religious Freedom Act by Thomas Jefferson in 1777 under the Virginia House of Burgesses. All right, that separated the crown property to now property that's now fall under what they call cestui use by those who became the trustees of the property. Why? Because now it became vacant. Why? Because they took the heirs out of the equation. Why? Because they took the king out of the equation by taking the natural person out of the equation. All right? What's a corporation soul? A corporation soul is a legal entity consisting of a single soul, incorporated, personified, incarnated, occupied by a single soul, natural person. The structure allows corporations, often religious corporations or commonwealth governments, to pass without interruption from one office holder to the next, giving possessors legal continuity, with subsequent office holders having identical powers and possessions to their predecessors. All right? A corporation soul is one of two types, corporation and the other being corporation aggregate. So you got a corporation soul and corporation aggregate. You have to understand that in regards to you being an heir to the estate that was promised to you based off the land as a rodeo belonging to the true owner. And the true owner is the crown. Because the true owner of the crown, personified by the monarch who wears the crown, is under the jurisdiction of what they call crown land. And crown land is entail. We proved it by way of what we call statute. All right? Let's go back to the statute. Now we're really about to grow. Estates entail are abolished. From the time of Edward I, right here. All right? So the New Jersey's Congress, which consisted of the House of Representatives and the Senate, have amended the laws going back to the laws governing ownership of property from what they call primogeniture, which is based upon entail estates, all right, as established by Queen of Pentores. All right, let's visit that real quick. Queen of Pentores. The purpose of Queen of Pentores. The donors conditionally boss. That's it. All right, you don't see on the banner, you don't see Scotland and Ireland there. You just see the three lines that you see behind us. All right. Actually, it is quinipitoris. That you cannot alienate land by through subinfeudation. You couldn't do it. Right here. Prior to the Norman conquest of England in 1066, the Anglo-Saxon law of land succession was customary. Land or folk land, as it was called, was held in the allodial title by the group, meaning the group held the land. It was probably a little relevance with the titular of the clan or family died. Traditionally, lands continued to be held in communities by the group. The exact nature of the allodialism as it existed in Anglo-Saxon England has been debated, but to no definite ends. On one side, it has been argued that in a Marxist and Saxon allodialism was a highly idealistic, socialist, communal-narrative state, countering this utopian view with Numa Dennis Fistel de Colanges in his essay, The Origins of Property and Land. All right. Now we know when you're dealing with land, we can take a chessboard for example. The whole land is allodial, but we know when the land is given out, it's given out in fiddle tenure. So this is what they mean. This is when you have a checkboard, we have the land, you have the parcels of land, which is the checkerboards, you have those who occupy the land, which is the peasants, which are the pawns, you have the knights are the knights who protect the king is his castle on the land, that's allodial, that's owned by the king, and advised by his bishop. All right, we know the rook represents the castle, the bishop represents the visor, and the king and queen represent those who rule the land. All right, very simple. After the conquest, make sure y'all see this. After the conquest, the rule became one of primogeniture inheritance, meaning that the eldest surviving son became the sole heir of the baronial estates. The intent of primogeniture inheritance was to keep large lands holding in the hands of relatively few trustworthy lords. That's how it was designed according to our ancient ancestor practice. All right, agnatic succession. All right, agnatic succession. The children of tenants were assured their inheritance in the land. This also meant, as practically, that land could not be sold or bequeathed to the church. The ancient method of the Normans was to grant to the church in Franklimont. This is called statute of mortmain, right? Because if there is no heir, then automatically it results to the crown when the crown represents the church. All right? It was a street. That's the concept of the crown. It's a street. Matter of fact, let's just prove it. New Jersey Provincial Council, the crown. Let's click that. Let's go to concept. The concept of the crown took form under the feudal system, going back to William the Conqueror. Though not used this way in all countries that had the system, in England, all rights and privileges were ultimately bestowed by the ruler. All right? Not everybody, by the ruler who decides to give it to everybody. All right? Land for inheritance was granted by the crown to lords in exchange. This is called a landlord. All right? That's where that comes from. Land, for instance, was granted by the crown to lords in exchange for feudal services, and they in turn granted land to lesser lords. One exception to this was common soakers. Owners of land held as soakers held is subject only to the crown. You hear that? Which such lands become ownerless, they are said to escheat, return to the direct ownership of the crown, i.e. crown lands. Bona vacatina is a royal prerogative by which unowned property, primarily unclaimed inheritance, becomes property of the crown. I can't say it no more clearer than that, y'all. All right? It says one condition was free and common soakers. Let's look at that. Free and common soakers. This is nothing strange. New Jersey revised statute. This is legislative from Parliament. This is Parliament's legislation that you're reading. All right? The tenure of honors, lands, tenements, of inheritance of an estate of inheritance at any common law, at the common law, held either by the King of England or of any person or body politic or corporate at any time before July 4th, 1776, and declared by Section 3 of an act entitled An Act Concerning Tenures, passed February 18th, 1795, is to be turned into holdings by free and common soakage from the time of their creation and forever thereafter. Shall continue to be held in free and common soakage, discharge of all the tenures, charges, and incidents enumerated in that said Section 3. So that means that the land has escheated to the crown. So this free and common soakage is called the King's Revenue. All right? The King's Revenue. You see it right there. I've showed you that in the legislative statute. I'm showing you in the historical records. I'm showing you from all standing points. Let's go back. Okay. Let's move on with the lesson. All right, here we go. Edward the First. Edward the First was King of England. We know as King of England, he governed North America because his name is in the statutes pertaining to the entail estate that was preserved under the donors condition of the Bush under the statutes of entail that New Jersey abolished. All right, they unlawfully abolished the right for the preservation of our land that was left in entail for heirs, but they assumed there was no heirs. All right, so that brought on the process of what we call subjugation, selling the land, where he passed laws called Quint and Pretorius to not sell the land because he said you couldn't subjugate the land. All right, so that's our grounds to petition and petition a right. Petition a right is a prerogative of the crown. All right, a petition a right, and this is validated in Chisholm versus Georgia. All right. Chisholm versus Georgia, a Supreme Court case, 1793. Everybody see that? 1793. You've seen it in statutory form, because under 46:3-10, it says no claim based off uses and customs of an entail estate will be barred in lieu of a interest in the state held in fee simple. All right, and we know common recovery is a violation of law because it turned entail estate into fee and simple. And once it became fee and simple, it was able to be sold under what we call due to eminent domain powers of what we call the states under what we call police powers. All right, so let's read what Chisholm versus Georgia said. The only remedy in a case like that before the court by which, by any possibility, a suit can be maintained against the Crown of England, all right, or could be at any period from which the common law as enforced in America can be derived, I believe it is that which is called a petition of right. It is stated indeed in Com Digest 105 that until the time of Edward I, the king might have been sued in all actions as a common person. And some authorities are cited for that position, though it is even there stated as a doubt. But that same authority adds, but now none can have an action against the king, but one shall be put to sue to him by petition. This appears by the quotations or abstracts from Theolo Digest, which also one of the authoritative quoted in the former case. And this book appears from the law catalog to have been printed so long ago as the year 1579. The same doctrine appears, according to the quotation of Blackstone's commentaries, to be stated in Finch's Law 253, the first edition of which it seems was published in 1579. So as you can see, in Chisholm versus Georgia, that a right to petition in lieu of a lawsuit against the state has been always recognized all the way back in the time of Edward the First. All right? Of Edward the First, the son of Henry the Third, the son of John, the son of Henry the Second, son of God, the fifth kind of man Jew. All right? These are facts. You can't dispute. All right. Let's go ahead. Let's go back to the Dred Scott case. So we can understand how slavery started, all right? Pertaining to here in North America. We must understand that. Not what we assume, but what those magistrates say in regards to the institution of slavery, the regulating of slavery, and those who were subject to slavery. All right? That's the standing point or the foundation that each and every one of you needs to be standing on. All right? Because Dred Scott case was a case that involved each and every one of you status as it exists today. Presently. All right? Presently. Because Dred Scott was not considered a citizen. He was a slave. He can be a citizen of the United States under the Articles of Confederation, and he cannot be a citizen of the state. All right? If anything, he was property, shadow property. All right? So listen with open hearts and open eyes to what Dred Scott case, as stated by Chief Cheney. Because this case right here, Chisholm versus Georgia, was by Chief Justice Cheney. Let me make sure. Chisholm versus Georgia. I think this was Chief Justice Cheney, or was it United States versus O'Keefe? No, that's United States versus O'Keefe. My bad. Sorry about that. United States versus O'Keefe. That's dealing with Chief Justice Cheney, the same judge who ruled in Dred Scott versus Sanford. All right, and Chief Justice Cheney and United States versus O'Keefe, both there were the right to petition the king or queen, vice versa, in lieu of rights that were being violated at the time of the colonies. All right, for an English subject, because we know Negroes, colors, black people were emancipated in England. We were free in England prior to the 13th and 14th Amendment. We were free. We have always been free. These are in the Blackstone commentaries. Somerset versus Stuart. That was in the 17th century. All right, let's continue. Where was I at? Dred Scott versus Sanford. Pay very close attention. The weight of the decision is sought to be impaired from the terms of which it was described by the exuberant imagination of Quran. The words of Lord Mansfield in giving the opinion of the court were such as were fit to be used by a great judge in the most important case. It is a sufficient answer to all the objections to that judgment that it was pronounced before the Revolution, that it was very considered by this court as a highest authority. For near a century, the decisions in Somerset case have remained the law of England. The case of the slave Grace, decided by Lord Stawell in 1827, does not, as has been supposed, overrule the judgment of Lord Mansfield. Lord Stawell held that during the residence of slaves in England, no dominion, authority, or coercion can be exercised over him. Under another head, I shall have occasion to examine the opinion of the case of grace. To the position that slavery can only exist except under the authority of law, it is objected that in few, if in any instance, has it been established by statutory enactment. There is no answer to the doctrine laid down by the court. Almost all the principles of the common law had their foundation in usage. Slavery was introduced into the colonies of this country by Great Britain as early at an early period of this history, and it was protected and cherished until it became incorporated into the colonial policy. Did you hear that? Did everyone hear that? All right. Slavery was brought into the colonies by Great Britain. We know Great Britain was established by the kings of Scotland. All right? By the kings of Scotland. It says there is no slave state where the institution is not recognized and protected by the statutory enactment and judicial decisions. Slaves are made property by the laws of a slave state, and as such are liable to the claims of creditors. They descend to the heirs are taxed, and in the South they are as subjects of commerce. Once again, I repeat. It is an immaterial whether a system of slavery was introduced by express law or otherwise, if it had the authority of law. There is no slave state where the institution is not recognized and protected by statutory enactments and judicial decisions. Slaves are made property by the law of the slave states, and as such are liable to the claims of creditors. They descend to heirs, are taxed, and in the South they are subjects of commerce. Did anybody hear that? Slavery is emphatically a state institution. All right? Not only was it brought over by Great Britain, it was instituted and incorporated into the colonies, which are now called states. And it was emphatically a state institution. In the 9th section of the first article of the Constitution, it provides that the migration or importation of such persons as any of the states now existed should think proper to admit should not be prohibited by the conquerors prior to the year 1808, but tax or duties may be imposed on such importations not exceeding $10 for each person. That's why you all pay taxes. All right? That's why you all pay taxes. Let's go to 548. So slavery was in fact a part of the United States through what it said, Section 9. What is it? Section 9 of Article 1. Right there. Everybody see that? Y'all need to be highlighting that. If you migrated here or immigrating here, you are a slave. The Dred Scott case just said it. All right? Let's go to 548. Sorry about that. These judges were very aware of the status of us who are misnominated as Negro, Black, and Ethiopian. They know you are English. That's fine. Right here. Many states, on the adoption of the Constitution, or shortly afterward, took measures to abolish slavery within their respective jurisdictions. It is a well-known fact that a belief was cherished by the leading men, South as well as North, that the interest of slavery would gradually decline until it would become extinct. the increased value of slave labor in the culture of cotton and sugar, and we know cotton was paramount in Mississippi, all right, prevented the realization of this expectation. Like all other communities in the states, the South were influenced by what they considered to be their own interests. But if we turn our attention to the dark ages of the world, why confine our view to color slavery? On the same principles, white men were made slaves, and all slavery had its origin and power in against whites. So it says here in the dark ages of the world that white people were enslaved, all right? Because they're not confined into the term colored slavery, all right? When they say colored slavery, they're talking about colored people, all right? Don't lose sight of the term color, because we're going to revisit that again. Colored people, all right? Because we know colored people were being enslaved as Dred Scott fit that description, as all of us fit that description, because colored slavery doesn't just have to do with being in chains. It had to deal with migration here, migration over here. Either you migrated here or you were already here. I know I was already here because my ancestors were here in Mississippi before they colonized North America, all right? Because of my name, Jefferson. I'm going to prove it. All right, so let's go here. If it said that in the dark ages of the world, white people were considered slaves or were made slaves, so we must go to the time era of what we call the dark ages and review the history in regards to what Dred Scott is bringing to light, because we know that the script has been flipped on us. Somebody flipped the script on us. How was that done? All right, how was that done? We're going to find out how was that done. Let's go to 379. Back up. We know that Section 9 of Article 1 of the Constitution allowed for slavery to come into the colonies that were brought by Great Britain through Section 9, Article 1 of the Constitution, and it was incorporated into the colonies, now called states. It says right here in point 379, for the regulation of slavery, it says, it is a settled doctrine of this court that a federal government can exercise no power over the subject of slavery within the state. That's why they had planned on abolishing slavery, as it said in the Dred Scott case. So they had to think of another way of putting forth slavery, and that was through migration. All right? And that's happening as we speak. New migrants coming in every day on busloads. All right? It is a settled doctrine of this court that the federal government can exercise no power over the subjects of slavery within the states, nor control of the intermigration of slaves other than fugitives. So now they talk about the intermigration. They said in Section 9 of Article 1 that slavery was part of the colonies through migration, and now they're dealing with the regulation of slavery in lieu of intermigration of slaves and other than fugitives among the states. Nor can the government affect the duration of slavery within the states other than by legislation over the foreign slave trade. All right. So the regulation of slaves by way of the state legislation, going back to the incorporating of slavery by way of the state legislation, was done by Article 1 and Article 4 of the state's constitution. How we know it? Let's read it. It says, the power of Congress to adopt sections of the act cited must therefore depend upon some conditions of the territories which distinguish them from the state. When we're talking about the states, we're talking about the colonies from the Confederate States, all right? Because the colonies, i.e. the 13 colonies, couldn't practice slavery anymore. They had to abolish it, all right? This is why Somerset and Stewart is very important as a result of the slave, what's called the Fugitive Slave Act. All right, the Fugitive Slave Act allowed the state to intervene to bring slaves back to their to those who they ran away, i.e., their creditors or i.e., their slave masters. All right, their creditors. It says here. It says the power of Congress to adopt sections of the act cited must therefore depend on the conditions of the territories which distinguish them from the states and is subject them to the control more extended. The section of the fourth article of the Constitution, you hear that? The third section of Article 4 of the Constitution is referred to as the only and all sufficient grant to support this claim. So they were seceded land by creation of a so-called statute in lieu of the third section of Article 4 of the Constitution. All right. It is that new states may be admitted by the Congress to the Union, but no new state should be formed or erected within the jurisdiction of any other state, though any state be formed by the junction of two or more states or parts of the state without the consent of the legislature of the state concerned as well as of Congress. So they're trying to regulate slavery by taking control of the states through the Articles of Confederation, which surrendered the powers of the states to that other Articles of Confederation, which you now call the United States. Why? Because we know that through Article 1, Section 9, that slavery was instituted, incorporated, and it was regulated through Section 3 of Article 4, once Article 2 and Article 3 got into place, which deals with the executive branch and the judicial branch. All right? We see it right there. It's clear as day. All right, let's go here. So since we know how it was started and how it was implemented, incorporated, and regulated as co-signed by the Dred Scott case, let's go back to the origin of how it was brought and put on us, because we know that according to the emancipation of slavery, as Somerset versus Stewart, when a Negro stepped forward in slavery, he was free. All right? He was free. So how did we get in this condition? Because the people who were sitting on the crown of England were not the monarchs of England. They were Scottish monarchs who enslaved those Negroes, i.e. Dred Scott. He had the name of a Scottish king. They were the ones who brought in slavery because, as it said in Dred Scott, slavery was brought in by Great Britain in 1707 and incorporated in the colonies. All right, let's move forward. Let's go to 369. Now we're going to deal with the regulation of captive slaveries, of those regulation of slaves who ran away from their masters. We're going to see the regulations as we see in Section 3 of Article 4. We're going to see it's regulated. They're using this type of history that goes back to the ancient practice of servitude or slavery. All right? They're going to co-sign it. All right? Let's read it. Everybody hold that thought. I take a 3-minute break. Okay. Back to class. Very important paying close to this because now we're dealing with the regulation of slavery. We know how it was instituted here in North America by the Scottish kings, known as those kings who ruled Great Britain, England, Ireland, and Scotland. All right. It was brought over here, going back to the what we call the Treaty of Perpetual Peace in 1502, which was the alliance of Scottish kings with the House of Lancasters, because we know that it stated that in regard to primogeniture, that was the reason for the War of the Roses. All right? That was the reason for the War of the Roses, and the War of the Roses were the result of the descendants of Edward the First. All right? And we know Edward the First is found in legislation and statutes and case law here in what we call North America. All right? And he was married to a Spanish queen, Eleanor Castile, who was governing territory here in North America under Doria of Spain, which all that territory was ceded here to what we call the Kingdom of England, known as Great Britain, composed of Ireland and Scottish monarchs sitting on the English throne as de facto monarchs by way of what we call prescription of sovereignty, claim to be the real sovereign, and they're actually not. How we know? I'm proving it to you right now. Okay? So now we're dealing with the origin of slavery, the institution of slavery, and the regulating of slavery that was incorporated into the colonies that is being done by your present governments on all 50 states. All right? You are a slave of your state. All right? Let's read it. The public law of Europe formally permitted a master to reclaim his bondman within a limited period wherever he could find him. One of his capillaries of Charlemagne abolished his rule of prescription. They got that rule, prescription. All right? He directed that whatsoever within the bounds of Italy, either the runaway slave of the king or the church or any other man should be found by his master, he should be restored without any bar or prescription of years. Yet upon the provisions of the masters of a Frank or German or any other nation foreign, but if he be a Lombard or Roman, he shall acquire or receive the slaves by the law which has been established from ancient times among them. Check this out. Without referring for precedents abroad or to the colonial history for similar instances, the history of the Confederation and Union afford evidence to the attest the existence of this ancient practice. All right? We just seen it because it was brought in from these people who claim to be ancient. All right? 1783 Congress directed George Washington to continue his remonstrances to the commander of the British forces, respecting the permitting Negroes belonging to citizens of these states to leave New York and to insist upon the discontinuance of that measure. In 1788, the resident ministers of the United States at Madrid was instructed to obtain from the Spanish crown orders to the governor in Louisiana and Florida to permit and facilitate the apprehension of fugitive slaves from the state, promising that the state would observe the like conduct respecting the fugitives from Spanish subjects. All right? So Eleanor of Castile. All right? Eleanor of Castile was a Spanish king. And we know that all the territories that they controlled were succeeded back to Great Britain through the Treaty of Paris in 1783 when slavery still was being done by them. All right? And it said right here that there's no ancient precedent from cross seas nor need to be referenced in the colonial history for similar instances to validate this ancient practice that was governed by these ancient laws. 1 second. It says here, the ordinance of William the Conqueror that a resident of any of the servile population of England for a year and a day without being claimed in any serial borough, wallet, town, or castle of the king should entitle them to perpetuity, liberty, and a specimen of these laws. All right. This going back to the time of William the Conqueror. All right. The invasion of Normans on England soil when the soil was owned by the kings of England. We know that prior to William the Conqueror, the only king that was there ruling the lowly land was Edward the Confessor. All right. Let's go a little further. This is all the Dred Scott case. The question to be raised, in my opinion, the question to be raised with the opinion of Lord Mansfield, therefore, is not in respect to the incongruity of the two systems, but whether slavery was absolutely contrary to the laws of England. For if it was so clearly, the American law could not operate there. So we know that American law was based upon slavery, that due to the incorporation of slavery through the colonies, as is stated in this case. All right, which was brought over by Great Britain, which was the Scottish kings who ruled the British Empire. All right, but they were never really truly kings of England because the laws of England, slavery cannot exist, as it's just stated. The laws of America was contrary to the laws of England in reference to slavery. Historical research ascertains that at the date of the conquest, the rural population of England were generally in a servile condition, and under various names denoting slight variances in conditions. They were sold with the land like cattle and were a part of its living money. Traces of the existence of African slaves are to be found in the early chronicles. Parliament in the time of Richard II and also Henry VIII refused to adopt a general law of emancipation. Acts of emancipation by the last name monarch and by Elizabeth are preserved. So I mean, from the time of William the Conqueror to the time of Henry VIII, slavery was instituted. There was different types of slavery. You had what they call serfdom, and then you had that real horse slavery. All right, bondage. You had those who are called colliers, or what they call those who work with coal, as we're going to read in a second. All right, check this out, y'all. But they're talking about Africans. This is what's important. They're talking about colored people. They remember said, without the exception of colored people, that white people were enslaved in the dark ages of the world. All right, but now all of a sudden we're enslaved from the time, as we're speaking about in the time of the conquest of William the Conqueror, all the way to the time of Henry VIII, which no laws in regards to emancipation were implemented until 1865. Okay, until 1865. The African slave trade had been carried on under the unbound protection of the crown. We know what the crown is, all right? But who's sitting in the office of the crown is what the question needs to be asked, all right? Have any of you asked that question? All right, because this question has been asked for over near 2 centuries. When the case of Somerset was heard, and no motions for its suppression had ever been submitted to Parliament, while it was forced upon to maintain an unwilling colonies by the Parliament and Crown of England at that moment. So the colonies didn't want to deal with the laws that said that slavery could not be practiced because slavery was implemented in the colonies. Let me read this again. The African slave trade had been carried on under the unbound protection of the crown for near 2 centuries. When the case of Somerset was heard in regards to emancipation of slavery or slaves on being England being emancipated and cannot be allowed to be returned back to their slave masters under the fugitive slave clause, the colonies were not agreeable with it. It said, in no motion for suppression had ever been submitted to Parliament, while it was forced upon and maintained in unwilling colonies by the Parliament in the Crown of England at that moment. 15,000 Negro slaves were then living in that island. You hear that? Where they have been introduced under the counsel of the most illustrious jurists of the realm. And such slaves have been publicly sold for near a century in the markets of London and the northern part of the Kingdom of Great Britain. There existed a class of 30,000 to 40,000 persons, of whom Parliament said in 1775, under King George III, many colliers, coal heavers, and salters are in a state of slavery or bondage, bound to the colliers and salt works where they work for life, transferable with the colliers and salt works when their original masters have no use for them. And whereas the emancipating or setting free the colliers or coal heavers and salters in Scotland, who are now in a state of servitude, gradually upon reasonable conditions will be the means of increasing the numbers of colliers and coal heavers and salters to the great benefit of the public, without doing any injury to the present master, would remove the reproach of allowing such a state of servitude to exist in a free country, etc. And again, in 1799, they declared that many colliers and coal heavers still continue in a state of bondage. No statute from the conquest till the 15th of King George III had been passed upon the subject of personal slavery. This fact have led to most eminent civilians of England to question the accuracy of this jurisdictionum by private authority was committed by eminent magistrates who pronounced it. So the judicial judges who were initiated under the Article of Confederation under Article 3 was incorporated by Article 2 to validate the laws that were incorporated under Article 1 by way of regulating by Article 4 of the United States Constitution that originated from the Articles of Confederation. All right? There you see it right there, that the government you have now is based upon modern day slavery. All right? Modern day slavery. There was another point I wanted to go to right here. Let's go right here. In order for them to regulate this slavery of the so-called colored people or colliers, all right, only for them to regulate that, they had to claim new territory, all right, by way of succession through the third section of Article 4 of the Constitution, and referred to as the only and all sufficient grant to support this claim for the regulation of slaves to return them back to those slave masters, subject to the Confederate States, all right, which included Mississippi, Alabama, Georgia, etc. All right. So now, what is a collier? All right. Let's look at that. Colliers and salters, Scottish slaves. So recently as 1799, there were slaves in this country. 25 years before that, in 1775, there must have been thousands of them. But this was the condition of all our colliers and salters. They were all literal slaves. All right? You've seen it mentioned in the Dred Scott case, right? 1775, you had the act. 1 second, my screen acting up. Bear with me. with me, everyone.